After 5 weeks of testimony from government witnesses about how their clients had bribed and bullied their way into the halls of state power, defense lawyers in a major New York corruption trial finally got their own day in court. Well, half a day. Lawyers representing a former top state official, Joseph Percoco, and 3 executives accused of bribing him had been promising for days to mount a vigorous defense case, complete with documents, videos, and more than 20 potential witnesses. The list included several notable names, including a former top aide to the governor, Mr. Percoco's wife, and 2 of the defendants themselves. But by the time the defense lawyers actually began their case, it seemed to have been scaled back significantly. Only a few brief witnesses, mostly state employees who testified largely to paperwork and procedural questions, took the stand on Friday. Because of scheduling issues with other witnesses, the jury was sent home before lunch. The judge said Monday's proceedings would likely be abbreviated, too. Closing arguments, she said, might begin the next day, several days earlier than defense lawyers had originally predicted. All in all, it was an anticlimactic start to what had seemed, for a time, to be a potentially revealing and explosive string of witnesses. But legal experts not involved with the trial said that what the defense lawyers did not say, and who they did not call, may reveal just as much about their approach as what and who they did if the government's case is in shambles, as it may very well be in this case. It's not surprising that you either scale back the defense case or you simply rest, said Benjamin Brafman, a defense lawyer who has represented clients including Martin Shkreli, Harvey Weinstein, and Dominique Strauss-Kahn. The betting money would be that you don't push the envelope and let it fall off the table, when you may well be in a good position right now. Gerald Shargel, another veteran lawyer best known for winning the acquittal of the mafia boss John J. Gotti, summed up his own philosophy: quit while you're ahead. The potential weakness in the government's case to which Mr. Brafman and Mr. Shargel were referring was the stunning mid-trial arrest of Todd R. Howe, the government's star witness. Mr. Howe, a disgraced former Albany lobbyist, was cooperating with prosecutors after pleading guilty to 8 felonies, and said that he had facilitated the bribes between Mr. Percoco and his CO defendants. Mr. Howe was arrested after admitting under cross-examination that he had tried to defraud his credit card company after he signed his cooperation agreement with the government. But defense lawyers had also indicated other reasons for pulling back on their witness lists. Earlier in the week, they had suggested that 2 of the defendants, Stephen Aiello and Joseph Girardi, executives of a Syracuse area development company, might take the stand. But if they did, lawyers for Mr. Aiello and Mr. Girardi insisted, prosecutors should not be allowed to cross-examine them on their involvement with the so-called Buffalo Billion, itself the subject of an upcoming corruption trial. The Buffalo Billion refers to the infusion of $1 billion by Gov. Andrew M. Cuomo's administration into his signature upstate development project. But federal prosecutors have accused Elaine E. Caballeros, former president of the State University of New York Polytechnic Institute, and Mr. Howe of rigging bids and doling out favorable treatment to certain contractors. Milton J. Williams, a lawyer for Mr. Girardi, said allowing questioning on that topic would get into a whole mini-trial that would unfairly prejudice the jury. Prosecutors said defense lawyers had opened the door to that line of inquiry by arguing that Mr. Aiello and Mr. Girardi had been innocent victims of, rather than active collaborators with, Mr. Howe, when they allegedly bribed Mr. Percoco. They said they had the right to question the executives on the Buffalo billion to show they had been involved in sordid dealings with Mr. Howe before. Judge Valerie E. Caprani of Federal District Court in Manhattan seemed to agree. Why isn't it a fair response to your argument that your clients were duped to show that, far from being duped, your clients engaged in a different scam with Todd Howe? She asked the lawyers. Mr. Aiello and Mr. Girardi did not take the stand, neither did Lisa Toscano Percoco, Mr. Percoco's wife. According to prosecutors, much of the more than $300,000 Mr. Percoco received in bribes was funneled through payments to his wife through a low-show job with Competitive Power Ventures, orchestrated by a former company executive, Peter Galbraith Kelly, who is also a defendant in the trial. And Howard Glazer, Mr. Cuomo's former director of state operations, did not appear either. Defense lawyers have also been cognizant of the trial's length. Judge Caprani has already chastised them several times for what she called repetitive questioning, and she warned them that they were trying jurors' patience. On Wednesday, a juror sent the judge a note asking how much longer the trial would take. Judge Caprani turned the question on the defense lawyers. They objected, worrying that jurors eager to get home would become frustrated with them, and by extension their clients. Essentially, the effect is to blame defense counsel as a whole for the number of the days that we have left. Daniel M. Gittner, Mr. Kelly's lawyer, told the judge. That is just not fair.